Welcome to episode number 7 of Upstate and Litigate. I'm Derek Spada.
And I'm John DeGasperis. We're partners at the law office of Basch Keegan in Kingston, New York. We represent injured people in and throughout the Hudson Valley. Today is another episode of Upstate and Litigate, and we're going to talk about independent medical examinations. But first, if you like our content and you find the show to be helpful or informative, make sure you follow us and give us a like. Derek, I first want to talk to you about a joke that I came with today. Okay. You ready?
What's that?
It's a lawyer joke. All right. What type of clothes do lawyers wear to court?
I don't know.
Lawsuits.
Nice.
All right. Any cool wins for you recently?
I won an appeal in the second department, which is down in Brooklyn.
Were any of these mine? Because I know you're handling a few of mine.
No, yours is still pending out there. But
okay.
It was Maureen's case.
Okay.
And there was a slip and fall on a staircase, and there were some different building code violations. The stairs were wet. The handrail was made out of 2x4, so it was only on one side of the stairs, not two, even though it was a new staircase.
All right.
And whoever poured the concrete sloped it in the wrong direction so that water would puddle on the steps.
Oh, boy.
And the steps were perfectly smooth concrete, which looked nice when they were dry. But anyway, it just became slippery when wet. And still, it's a possible tough case as it is, but not one for summary judgment where it should be dismissed. So,
came out of Dutchess County, I take
out of
it?
Dutchess, yeah. So, won the appeal there, so the case is moving along. The only downside, I feel like, to the second department is it takes forever to get your appeal decided.
Yeah.
It took upwards of 2 years. But, we'll still get there eventually. It's just, patience is a virtue.
Justice delayed is no justice at all, right?
Yeah.
Any wins for me that we want to talk about here? Let's see. I don't think we talked about this yet on the show, but I just settled a motorcycle accident case for $245,000. There was $250 in coverage. $5,000 went to the property loss. My client had a fractured ankle with open reduction, internal fixation, so he's got permanent surgical hardware. Within 8 months of the accident, he was back on his motorcycle. I cannot believe this guy got back on his motorcycle. But it was
he's got a passion to ride.
He's got a passion to ride, man. And his ankle still bothers him, of course. He walks with a cane. He must put the cane on the motorcycle. But, he made a relatively strong recovery. It was Progressive. Progressive started by offering, I think they offered $200 and then moved in $5,000 increments for like 6 months. But we settled it right after depositions. And, they kept trying to buy it for less, but that's Progressive style. And the client held out for the max. So 2 good recoveries there. All right. So today, the case in chief involves independent medical exams. So why don't you just tell the viewers, what are we talking about when we use the term independent medical exams?
Well, first I put the word independent in quotes. So it's independent medical exams because it's not really independent. They're dependent upon the defense firms or insurance companies hiring doctors to examine someone who is injured. So our clients, they're the plaintiff in a lawsuit. So we bring the lawsuit on their behalf. As the case goes along, they oftentimes keep on seeing doctors for their injuries if they have ongoing issues. Then what the defense tries to do is they try to minimize the injuries, which is their role in the case. But either the defense firm or an insurance company, or sometimes they'll outsource to some third-party straw man, I'll call it, but some other company that hires certain doctors who will perform an exam on a plaintiff and then write a report. And now these exams aren't usually lengthy, I'll say. They can be as short as like 10, 15 minutes. Once in a while, a doctor will actually go on and spend a half hour, maybe 45 minutes with a person, and then write a report. And in the report, they'll do their best to minimize the injuries. So there's more to talk about here with these exams, but they're not really independent at all. The doctors are paid in a roundabout way by the insurance company, so they don't get a check directly from the insurance company. It goes either through usually through this outsourced company that then pays the doctor, or through the defense firm. But
one thing I was thinking about this morning as I was getting ready for the show, I thought we should have just called this topic, medical exams, and then as it relates to our work, they're called independent medical exams. But medical exams are inherent in the insurance industry. Everything from life insurance, right? You undergo an exam before you can buy your life insurance. Workers' compensation insurance, there are medical exams. There are medical exams for Social Security disability insurance. There are medical exams for long-term disability insurance. There are medical exams for what we do in personal injury litigation. So medical exams are inherent in the insurance industry, where insurance companies are going to be asked to pay out sums of money for people who are injured or allegedly disabled. But to your point, I think I agree with you. It's a misnomer to call it independent, because they call them independent because the insurance company is saying, well, listen, we can't pay the benefit until we have a doctor look over your records and confirm for us that, as you allege, you're hurt or disabled. But as you're saying, these doctors are typically, I'm just going to say, they're paid by insurance companies, plain and simple. So they're not independent. They're not objective because they work for the insurance companies.
But there's a difference between the doctors that I think that we see in terms of how they do their exams and reports, as opposed to other areas of insurance. So, like, for example, if you apply for life insurance, I feel like whoever does an exam there is more or less straightforward. They don't try to.
Oh, I disagree.
Push you.
They don't want you on the. If you think about it, they don't want to insure your life if you're not healthy, right?
Well, right, but they tell like it is. Meaning, they do want to sell the insurance ultimately, but of course, if you're not healthy, then they'll put that in the report that you're not healthy. But they don't take a healthy person and play them off like they're unhealthy.
That's true. Correct. Okay, so I see what you're saying. That's
and then even in the realm of workers' comp, I see the same doctors who do a workers' comp IME, which is independent medical exam,
mm-hmm.
and I see those same doctors in an auto accident case. And in the realm of workers' comp, the doctors do downplay the injuries, but not so blatantly.
Mm-hmm.
I feel like those doctors, again, maybe I can't quite call them fair, but they're closer to fair than what we see in the realm of a personal injury lawsuit.
Well,
the ones in our field, I mean, there's some out there who just blatantly lie,
they lie,
or they totally ignore evidence. So if you don't ignore it, if you just say, this is what this record here shows a bad injury, so I'll put that one aside and we'll just look at these records over here, then that's what I see more often. Either those outright ignore the evidence that's negative for their position, or they'll outright lie.
The workers' comp the workers' compensation medical doctors or examiners, they also have wiggle room because they have the whole sliding scale of disability. So they could compromise on something and say, well, it's a 50% disability, right? So now it puts that person in a weird spot where they're going to get 50% of their money versus choosing to go back to work. Where in our world, they're less ambiguous. And I think we should let's talk to the viewers for a moment about the most common types of independent medical examinations that we see. And I would say that we see a lot with car accidents, and that's because anybody who receives no-fault insurance benefits could be asked to go submit to an independent medical examination. And people typically ask, do I have to do this? And the answer is yes, you do. It's part of your insurance contract, or even if it wasn't your insurance policy, it's part of the obligation under that first party benefit to go to an independent medical exam. And the goal, I think, of the insurance company is to measure and determine whether or not you still need benefits. And if you still need benefits, how much benefit do you need? And also, wink, wink, can we start to get this human being off of our insurance roster soon? And then the other type of common independent medical examination that we see in our practice is the exam that is conducted within the context of litigation, typically nearing the end of discovery, where the defense, meaning the defendant's insurance company, gets to have you examined in order to help measure your damages and determine whether or not your injury is causally related to the accident and what the extent of your injuries are. Do you agree that those are the two most common?
Yeah. Yeah, that's what I see.
Yeah. And then, we do, I think there's a lot of crossover between the independent medical exams that are conducted in workers' comp, because I'll refer to them a lot or use them to my advantage, or if the workers' comp IME is not favorable, I'm aware of that, but you can't really use them as evidence. You can just kind of use them as guidance.
Yeah, but you could still call one of those doctors if they're good for it. If the case goes to trial, you could call one of those doctors to testify.
I recently asked a workers' comp IME doctor to come testify for me because I represent somebody who was injured in a car accident, claiming a head injury. And within the context, of course, the accident happened while she was working. So in the context of her workers' compensation claim, she was twice evaluated by a neuropsychologist. Then the same company has the litigation, right? So they're insuring the accident itself. And they had new IMEs done, neuropsychological exams. Of course, that neuropsych examiner says that the plaintiff is not injured, has no mental disability. So I was like, I asked the first workers' comp doc, can you be my expert? Because you work for the same insurance company. And of course, she won't do it. But, you, a few years ago, started asking your clients to do something unusual during their independent medical examinations. And I think I still have mixed feelings about this, but I'm coming around to your side a little bit. But tell the viewers what you encourage your clients to do during their independent medical examinations.
I started to tell my clients that they should record the IME with their cell phone. So you can set up your cell phone and do it on video, or keep it in your pocket and just do it, with audio. And well, first of all, in New York State, that's allowed. You are allowed to. It's called the first party recording, so it's permissible. And
meaning that as long as one party consents to the recording of any conversation, and that one party can be the person recording, you're allowed to record any conversation you want, even if surreptitiously.
Yes. Yeah. And what I was finding is that with certain doctors, the clients would come to me, after I would get their report, and I would talk to the client about the IME report, what's in it or not in it. And the client would tell me that the doctor stated during the exam something like, for example, when they would do range of motion testing on their neck, the doctor would say, well, turn your neck to the left. And the person would go like this. That's as far as I can go. And the doctor would say, oh, okay, I see that limitation. And mention, observe these limitations and comment on them.
Yeah.
And then in the report, the doctor would write, everything's normal.
Mm-hmm.
And then it comes down to my client's word against the doctor's word, because there's no recording of it. And the doctor is often alone in the room, or once in a while there's a nurse, but the nurse isn't doing anything more than sitting there. So with a recording, you can then either show, if it's video, or at least overhear the doctor stating that he's observing these limitations and these injuries. And then if he states that during the exam and writes in the report that everything is normal, the person's fully healed, there's no injury here, then the two don't match up.
I think the medical examiners sometimes go much further and say to the client, this is a serious injury, or I'm going to write a good report for you. Or I think you may, I'm not allowed to say this to you because it's not a physician-patient relationship that occurs during that IME. But the medical examiners will say, you may want to contemplate a second opinion or surgery, whatever it may be. And then as you described, the report says something very, very different. So I'm starting to come around to this idea of recording the conversations. I think one of the reasons I not that I'm opposed, but half of my clients, it makes the idea of recording the conversation makes them nervous. And I'm like, sometimes I'd rather just focus on what's going on, but I am coming around. I'm going to say something else too. And I've had IME doctors tell me this too now. The third party, the company that's hired to basically set up the independent medical examination and maintain the relationships with the medical examiners, they change the reports. So the doctors dictate what the report should say. That goes to the third-party company that set the exam up to type out, and they're changing the reports. And if either one, the doctors are in on it, which I wouldn't question that for the slightest, because they make a lot of money doing this. And two, the doctors are naive or ignorant of the fact most of these things are electronic signature anymore. And unless you have a trial to really test the veracity of the doctor's opinions against what's contained in the report, we will never know. But I think that those third-party companies are changing the reports. You've seen the New York Times articles on this in the past. Yeah. I've had 2 local doctors tell me that they've received reports back from the typist, and it's different than what they said. So, they're in on the game too.
Yeah. And I also feel that if doctors write, I'll call them good reports, meaning if they put injuries in the reports, those doctors don't get hired back in the future.
They don't last long.
Yeah, they don't hang out long. And once in a while you get a good IME report, it's good for your client.
Yeah.
Meaning because it's fair and honest. And then you never see that doctor's name again.
Yeah. Yeah, and don't get me wrong. I mean, sometimes you have such a catastrophic injury profile where the doctors have to concede the injury, right? Because otherwise they would have zero credibility. But then what they may do is try to say, well, this person was suffering from this condition or a similar condition beforehand, so maybe this accident really didn't change their ultimate sort of destination in life, right? Or yeah, they had that injury, but there's this one medical record that says they're doing well. And it's like, yeah, they're doing well despite the fact that they have a rod in their leg now, and have the constant pain. But yeah, they can get around their house all right, so they manipulate these one-off records. The other thing I wanted to talk to you about, and I think you'll agree with this, because I actually remember you dealing with this as a member of the Ulster County Bar Association. Personal injury lawyers, we often get grief for directing our clients to doctors that either accept certain insurances or doctors who understand how to handle trauma better than, general practitioners, or we direct clients to doctors who might just be a little bit more aggressive to test certain things or treat certain things. And the pushback is plaintiffs' lawyers use these doctors to make up claims, to extract more money from these claims than what the claims would otherwise be worth. Meanwhile, insurance companies have armies of doctors, right? I mean, you and I have like 2 doctors that help our clients in the entire Hudson Valley willingly and sort of like go above and beyond. But insurance companies, every doctor in town is on their roster. So what do you have to say about that?
Well, there's 2 things. So, there's like this overarching umbrella of the insurance industry. And the insurance industry, for example, with a car accident, you have to use no-fault insurance, which is your own automobile insurance. So if you're injured in a car accident, use your own automobile insurance to go see a doctor. Now, there's a lot of doctors around who don't want to deal with no-fault insurance because they're difficult to deal with. They have billing issues all the time.
Pays nothing.
Yeah, they pay a very low rate. And so doctors look at it and say, well, if you're injured in a car accident, I don't want to treat you because I'm going to get paid, $33 to see you, and it's not worth it. So that automatically wipes out a big segment of doctors
Correct.
who don't even want to see your patient or your client. So now you're limited to a handful of doctors who even see you. And then out of those doctors, there's a lot of doctors who just won't do much for you. Maybe it's because they're getting paid $33 or whatever it is. They don't really do much for someone who's actually injured. They just get a 5-minute visit, and then they're on their way with some pills or whatever. That's kind of all that they do. So then if you want to find a good doctor in that segment of doctors who accept no-fault insurance, it funnels down even further, and you've got like maybe 2 within a 30, 40 mile radius of here. And those couple doctors then get a lot of our clients because they're actually good. And by good, I mean they'll send someone out for an MRI. They'll spend more than 5 minutes with the person. They'll talk to them, give them actual advice, give them something other than pills to go treat their pain. And so then those 2 doctors kind of stand out because they see their names again and again and again. And I'd like to send my clients to other people, but there's no one else who's going to do much for them.
Right.
Now, the flip side is the insurance company, or plural companies, have lots of doctors who they can choose to send someone to. And those doctors get paid quite well by the insurance company for their exams. So to do an IME and write a report, I mean, it varies from doctor to doctor, but it's it's $1,000 at least, and usually more than $1,000 to look at some medical records, examine a person, write a report. It's in the thousands we're talking. And then if the case goes to trial, those doctors are paid sometimes upwards of $10,000 to come to trial. And their testimony lasts maybe an hour, maybe an hour and a half. So, of course, you have to prep for it beforehand, but you're looking at a half day, you get paid $10,000. And doctors do this again and again and again. And they, the ones who do these independent medical exams on a regular basis make a couple $100,000 a year to really work part-time. It's a very limited part-time job.
I mean, I can identify the profile of an independent medical examiner that works for an insurance company. Old, white, retired orthopedist.
Yeah.
That is their retirement, right? So they make a killing while doing surgery as a practicing orthopedist. And then when they want to slow down, they maintain an office in their old practice, and then they go work for an insurance company. And so how many orthopedists are at your local orthopedic group? 20, right? So every year, peel 2 off at every practice throughout the country, and they then go work for the insurance companies. And they do the bidding for the insurance company time and time again. And I mean, it borders on corruption. But what are we going to do? This is every day for us. Our clients come to us. They go to their primary care physician, which is the natural first step after a major accident, right? But with all due respect to primary care physicians, it is my professional opinion that they're not equipped to handle major traumas of the musculoskeletal systems, of joints. You need to be with, specialists, orthopedic doctors, neurologists, neurosurgeons, that type of thing, pain management. And the clients don't know where to go. And we have to try to help them find medical care. That's all I'm trying to do. When I refer a client to a doctor, I usually don't know these doctors. I think I don't know any of them. I get no kickback. I've never been taken to dinner. I think I've met these people once or twice, maybe in a courtroom when they're testifying. I have nothing to gain except just try to help another human being access the medical care that they need following an accident, because the insurance industry owns every other white jacket in town, right?
Yeah, it's really a form of insurance fraud, but it's reverse insurance fraud.
Oh, sure. But I thought you were going to touch something earlier about the insurance industry creating these myths that we all believe, right? They're like wives' tales. It's like, oh, don't file an insurance claim after an accident because your premiums will go up. In actuality, your premiums don't really go up all that often unless you're a problem driver, right? You're having 7 accidents a year, hitting 2 deer a year, a guardrail every year. Well, of course your rates are going to go up. But if you just have a one-off random accident and it's not your fault, your premium's not going to go up. And by the way, you can't do anything to control that anyway, because if there's an oil spill in the Gulf, they're going to increase your premiums anyway to offset the loss. So you're doomed as it is.
If it's not your fault, they're not supposed to raise your rates.
Right.
And if they do raise your rates, you can shop around. You can change insurance companies, every week if you want to. You can change constantly.
But my point is, this whole idea that personal injury lawyers direct their clients to go get treatment, to feign these claims, it's an absolute fallacy that we don't do it. I don't have time to do it, right? I'm only looking for the better cases. Like, I want the cases where the treatment is organic in nature. The client has already had the surgery before they even get to you, type stuff, right? But otherwise, if I do give a doctor's card to a client, it's because they're the only doctor that will help these people.
Yeah, that's true.
Is there anything else about independent medical exams that you want to talk about?
Well, so what do you do about it?
Well,
meaning like, how do you deal with this in the case? When you get this report, when you know your client's injured, they're not in a wheelchair necessarily, but they've definitely got injuries that are from the collision or fall or whatever happened to them. and you know that the injuries are real, you see it in the medical records, you're confident you got a solid case, and you get this IME report that says more or less there's no injury here. How do you deal with that?
So a couple things I do with IMEs. One, I try to always send them to the client to read over, because oftentimes the clients will read them and say, well, this isn't true. I didn't say that. Or, as for his opinion, he told me something very different. So I always send them to the client to read. Two, I read them, try to find inconsistencies between their opinions and the actual medical records. Sometimes, a client will be asked to go to multiple medical exams, and you can find inconsistencies between the doctor's own reports or two different experts' reports. And then sometimes I just say, F it. Like, let's go to trial, and I'll call you to task on it. And you're going to lose because you're going to embarrass yourself if you actually take that opinion. And I think it would frustrate juries. We could probably do a better job of this as the plaintiff's bar, but also as a law firm. But I do think that we should start to call certain experts to task. I mean, take a infamous orthopedic doctor with white hair that works in Orange County. He does all types of IME reports. Yeah. He was the first expert that I ever cross-examined, and he was old then, 13 years ago when I became a lawyer.
Oh, yeah. He was old 25 years ago.
The man has made millions of dollars doing the bidding of insurance companies, right?
Literally millions of dollars, because he's done these IMEs for 20 plus years.
Yeah. But what do you do to combat it? What are your thoughts on that?
I think every case is different. Every report is different, and I try to pick it apart as well as I can.
You're really good at that. I mean, that's part of your skill set.
It's hard though. It's a little. It takes time. So, for example, you have to look at the medical records or read the records, at least know what's in the records, and then look at the IME report and see what diagnoses were made or what information is contained in the person's medical records that's not in the IME report. So, oftentimes there's a format. So, at the beginning of the report, the doctor will talk about the history, meaning like how the accident happened and what the person told them about their injuries. Then the doctor goes through all the records that are reviewed. Now, oftentimes, if you look at the record review and a quick summary on each record, the doctor will leave out the critical diagnosis from each one. So, for example, if somebody has a tear in their knee or a disc herniation in their back or something like that, those little nuances will be omitted from a record. So it'll say like Dr. So-and-so diagnosed Mr. Smith with lower back pain, and kind of goes on from there, but leaves out the disc herniation, which is a critical injury.
This is why you're awesome at appeals and motions, by the way, because your level of detail is crazy. But go ahead.
And then with a conclusion, oftentimes things don't necessarily match up. So the thing that I always get hung up on is the range of motion testing, which I'll talk about in just a moment. But for example, a doctor will say that, especially someone's older, they'll say, well, the person had all of this degeneration, meaning, just changes due to age-related, things. Our bodies break down over time. So the doctor will try to pin all of their claimed injuries on the person's age. But then when they do the range of motion testing, they'll say it's full. So they've got totally normal range of motion testing. And then it's like, well, how the hell do you have full range of motion if your body's falling apart and you're old and decrepit? It doesn't make sense. And then at trial with range of motion, there's two possibilities with range of motion testing. So if you have a client with a shoulder injury and the person says, I can only move my shoulder this far, I can't go beyond this point, then the doctor will say, okay, and put that in the records, but also indicate that it's subjective, meaning the person has chosen to move their arm just this far. And that's it. The doctor leaves off there and says that it's voluntary range of motion. It's subjective. It's not, it's just as far as the person chose to move their arm.
This is in every report, by the way, too. It's like the number one way to combat range of motion is to say, well, it's subjective. Yeah, every report.
But then there's the American Guides to Impairment, which explains how to do range of motion testing properly. And I've never encountered one medical defense doctor who's done it properly. So the proper way is you do range of motion testing. The person says, like, I can only get my shoulder this far. You say, okay. Then you go on through the rest of your exam. You circle back 20 minutes later and you say, let me test your arm again to see how it looks. So if the person, you're supposed to use a goniometer, which is something that it's a device basically that shows you the exact number of degrees. Right. So for example, if this is, let's say, I don't know, if, that's 90, so that's let's say 80 degrees for, I don't know, say like 80 degrees is as far as the person can go, as opposed to all the way up, which is like 180. So if you're at 80 degrees, now it's hard 20 minutes later, if not impossible, to recall what range of motion you just showed the doctor if you really are faking it. So if I go this far and it's 60 degrees, now you're off by 20. Now the doctor has a basis to say that what the person is doing is not authentic. If the person comes within a couple degrees, again, if you're at 80 again or 82 or 78, whatever, you're close enough that it's hard, if not impossible, to replicate that feigned range of motion. But no doctor does that. They do it one time and they don't want to do it again.
These IMEs typically take 10 minutes. According to our clients, they're 10 minutes max. I mean,
there's a lot who are done 10 minutes. Once in a while, you'll find a doctor who digs into it more, but usually 10, 15 minutes. Yeah. And then I had another client.
By the way, there's like 30 people in the waiting room, all there for this insurance company to see this particular doctor. So there's no way he's doing thorough exams.
Yeah. And then I have one client who's, she's an attractive woman and she had a shoulder injury. So she went to the doctor's office. This was, during COVID. It was like late 2020. So it was, not at the outset of COVID, but it was going on, whatever. So she went there with her husband. The doctor asked her husband to wait it out in the car. He didn't want anyone else in the office besides anyone who needed to be there. So the client went in, and again, it was a shoulder injury, a little bit with her neck, but shoulder and neck. And the doctor told her to take her clothes off.
Oh my God! Oh my God!
So she was like, "All right." So anyway, so basically she had to, it's a long story, but the doctor made her take her pants off, and she was reluctant, but gave in and took her pants off for the doctor who wanted to examine her hips and knees and legs, which really weren't injured in the accident. There was no injury to her legs.
Yeah. Well, this goes to my point too, that people should know this. If you are asked to submit to an insurance medical exam, sometimes referred to as an independent medical exam, you have no physician-patient relationship, right? So you have no expectation of privacy with respect to what is discussed during that appointment. The independent medical examiner is not likely going to give you any medical advice, and you really can't include it in your medical appointments. I've been noticing more and more. I'll say to a client, all right, I want to make sure I got all of your medical records, and we'll go through the list of doctors. And then they're like, oh yeah, well, what about this so-and-so? And it's a medical exam. And I'm like, that's not your doctor. That's not treatment, So, but this whole analysis that you just gave, that's super in-depth, detailed analysis that does come in handy when you're writing a motion or doing a cross-examination. That is attention to detail that probably most other lawyers don't give to those IME reports, which I think makes you sort of exceptional at your job. But, I think on the day-to-day stuff, we just have to have a voice for injured people. I mean, there has to be a voice out there opposed to the insurance industry's objective of making money. And that's where we come in. That's what trial lawyers do. We're doing it not only in our practice on our day-to-day work representing individuals, human beings, but we're doing it at the state levels with the Capital District Trial Lawyers Association or the New York State Trial Lawyers Association. Is it NISLA? We have the American Association for Justice at a federal level. These are what we believe to be groups that have an interest in justice. We stand opposed to corporate interest and big business. We are the voices for humanity.
And the economic basis for the IME, I mean, it's sort of somewhat obvious, but to really boil it down is, if you have a case that, let's just say, for example, it's a solid case, and you would evaluate it at $75,000.
Right.
Then the person goes to the IME and gets this report that says there's no injury or it's all from pre-existing age-related changes or whatever that's going to say to downplay the injury. Now, the insurance company and defense attorneys will use that report then to try to bring the value down. Right. So the report, their outlay was maybe $1,000 or $2,000 to get this report, but now they're trying to bring your $75,000 case down to $45,000, and they're trying to save $25,000, $30,000 toward a settlement. So, again, I feel like we do a good job of digging in and not letting the IME affect the case, but there's a lot of lawyers out there who I don't think
I
they're
also
able to do that.
I'll say this. I have become so cynical of IMEs and independent medical examination reports. Sometimes I think there is just kindling. Like, they're garbage. I read it and it's like, whatever, bro. You're not changing my opinion of the situation, right? Like, we're just full steam ahead. That's actually where I'm at. If they don't make a motion, I don't read it to that detail that you're describing. I just think this is actual garbage. Your report is actual garbage.
That's how I look at it. Yeah.
The final point I want to make here, or maybe I want to ask you what you think about this. There was a judge who used to handle a lot of cases in Ulster County, female judge. I thought she was a great judge. She'll remain nameless here. But she, even as a judge, the neutral party, called independent medical examinations by a different name. She called them defense medical examinations, which I think is accurate, right? I mean, the defense is ordering the medical exam. So she would call them a DME. You and I don't do that. Do you think that we should?
I do think we should, yeah.
Do you want to make the commitment right here that Basch and Keegan, from now on, we will refer to these as DMEs or defense medical examinations to appropriately characterize what they are?
Either that, or if we're going to stay with the IME, it should be insurance medical exam. But I'm fine with DME for defense medical exam.
I think that we should try harder, because I think it's something as subtle as referring to these situations as accidents, right? And we could disagree about this, but most of the injuries that our clients sustain are not the result of accidents. They are the result of negligence. They are the result of someone failing to behave in a reasonably safe manner, right? Or failing to do something that a reasonably safe person would do. They are avoidable. They are not accidents. They are the result of human neglect. And so I would say now, for the last couple months, I don't call car accidents. I call them crashes, right? And that's something else that I think we could work on to improve our overall mantra. But let's talk about that. I think Basch and Keegan should commit to insurance medical exams or defense medical exams going forward. I think that's it for the case in chief. Now we're going to transition to, is it legal?
What will it cost to hire you or me, one of us, either of us or both of us, as a personal injury attorney?
All right. Well, here's the deal. To be totally transparent, there is a cost. However, there is no upfront cost. An injured person has to expend $0 upfront to consult with or hire an attorney. There's no out-of-pocket expense, which is why you should always call a personal injury attorney, because it costs you nothing to get a professional's advice about whether or not you have rights, and if so, to what extent. Personal injury lawyers work on a contingency fee structure. This means that we don't get paid unless we win, and we get paid. Our payment is contingent upon your successful resolution. We get a percentage of the overall recovery. So please don't let the expense of hiring an attorney be a deterrent. Everybody, whether you're poor or rich, has the right to legal counsel, especially when you're injured. Call a lawyer, you pay later.
And there's no fee unless we win.
That's right. And we're serious. And here's the other thing. Not only is there no cost, but let's say that after an investigation, we determine that there's no case or that we can't help you. Let's say after 2 years of litigation, a court of law determines that there was no liability on the part of the wrongdoer or the negligent party. You don't owe us money if there is no case. You don't owe us money if for some reason we lose. We just chalk that off as a loss. We incur the loss ourselves. We tell the IRS we lost on this one. We, personal injury lawyers, should never be asking their clients for money. Personal injury lawyers should never be sending their clients a bill unless the lawyer wins. All right, Derek, is it legal? And your question is, this is perfect for you. Ready? Give us a little education, Mr. Law Professor. What are the basic elements of a personal injury case?
Well, there's really two major elements. So the first is negligence, meaning that someone else was at fault for your injury. And then the second part is the injury and the extent of the injury. So with a case, you have to have both. Otherwise, there's no case. So someone could be very negligent, but then not cause an injury. Meaning, if someone could be driving 100 miles an hour and crash into your car, but if you somehow walk away with nothing more than really a scratch or a very minimal injury, you won't qualify to have a case. And so I get calls from people who are sometimes incensed when I explain to them that you don't have a case because you really have no injury, despite the fact that someone else was either speeding or driving drunk or whatever. That's just the way it goes. And then the second element is the injury, which is what the value hinges on. So if you have a minor injury, then you get a small amount, and if you have a more substantial injury, the value swings higher. The third element, which is something beyond everyone's control, it's a matter of, I'll call it luck of the draw, is insurance coverage. So you could have a $1 million case, but $25,000 in insurance coverage on the other vehicle and no underinsured coverage on your own vehicle, and a defendant with no assets, meaning as bad as your injuries are, you still might only get a total of $25,000 in your recovery.
Yeah.
So those are the two main elements. Again, negligence and injury. The third element as to where the value comes from is oftentimes insurance or assets.
I usually go with a little bit of a different approach there, depending on what my client or what the caller's experience was. So if you were in law school, I think you'd learn that there are 4 elements. There's duty, breach of duty, causation, and damages. And these cases that you and I handle can hinge on any one of those 4 elements, right? So like duty has to do with, did the person or the party owe you a duty? For example, if you crash your bike on Broadway in Kingston because of a pothole, you cannot sue the federal government. Why? Because the federal government doesn't control that road. They owe you no duty of care, right? Now, and then breach of the duty is, well, okay, well, who owns the road? Well, we know it's the city of Kingston. Is it safe to have a pothole in the road? No. Take aside some municipal factors that like change liability analysis. It's not safe to have a pothole in the road, so the city of Kingston breached its duty. Causation, if you already had a sprained ankle, you hit the pothole with your bike, but you're not hurt, you have no new injuries, you just have the sprained ankle from yesterday's football game, well, there's no causation, right? Then of course there's no damages. Causation has to do with, did the accident or I shouldn't say accident, but did the negligence cause the injury? And then if it did cause the injury, well, what is the injury and what are fair damages? And I can often, I think, disarm someone if I can't help them. And I know that they may be incensed, as you described, or pissed off if I tell them, listen, I can't help you. If I get into those legal factors, I think it actually disarms them and they kind of better understand why I'm saying no to the file. But real fast before we wrap, I do have a question for you. How do you handle a situation where when someone calls, they have an awful, awful injury, but there's no negligence? How do you deal with that person? First time you ever talk to them on the phone, they're clearly going through a tough time, life-altering injury, they're lost, they're upset. How do you deal with that one?
Well, that's a tough situation to be in, where
happens often enough though, doesn't it?
Yeah, the person has severe injuries and there's no one to sue because there's no negligence. First I'll hear out their story, hear out what happened, and try to think of any angle of negligence if one exists. But if it's not there, then I do my best to explain to the person that they're just in an unfortunate situation where there's just no legal way within the framework of the law to recover any kind of compensation for them against someone else who may have, who could have theoretically caused their injuries. If it's a situation where there's maybe workers' comp available, I'd steer them in that direction.
Yeah, right.
Or New York State disability, I could steer them in that direction.
Yeah.
But if it's not there, it's just a matter of talking to them for a little while, and it's just nothing that we can do to help them, really.
All right, so Derek, are you ready? What is
Sure.
your favorite historic landmark in the city of Kingston? And I have a feeling I know what you're going to say, and I think I'm going to have the same answer, but we'll see.
I'm going to go with the Senate House.
Bingo.
And it's in a great location in Uptown Kingston. There's so much history there. Too much to go into right here, but there's a lot there that happened in the early stages of New York State. But the grounds are beautiful. It's a nice park. You go there and have lunch or just walk through. The flowers are always nice. It's just a nice, quaint spot in Uptown Kingston to escape from Uptown Kingston.
And you and I are probably partial to the Senate House because our law office is located immediately adjacent to it. And the Senate House, by the way, served as the first ever capital of New York State for our viewers who did not know that. But, you and I walk by it or through it virtually every day. The state of New York dedicates a lot of resources to keeping those grounds in a nice condition. There are some gardens. It's open to the public. There are several structures on it that you can take tours of. I love the old sign as you walk down Clinton.
By the corner of Clinton and North Front Street.
Yeah, I don't know why I connect with that sign so much, but I agree. I like the Senate House. I think you're right. It's like a nice little escape of Uptown Kingston. My kids, for some reason, like to go there. I mean, there's not much to it. It's just like a big open yard and some gardens, but we'll play a nice round of hide and seek in there or something like that. So I agree with you. I like the Senate House. All right, now we got closing remarks.
Thanks again for listening. We hope you found this interesting and helpful.
Yeah, if you have any questions about insurance medical examinations or defense medical examinations or any examination at all that an insurance company may ask you to submit to, feel free to give Derek or I a call. We'd be glad to answer your questions. We deal with this every day with our clients. But otherwise, we really hope you like this episode. Please don't forget to follow us and subscribe to our channel. We would appreciate that. And we've got a lot of great educational content to come.
See you next time.